What do you do if you're named as an executor in a will, and then you get paperwork from one of the other heirs saying they want to be the executor? I'm going to answer that question in this video. Hi, I'm attorney Dan Scott, and I just came back from probate court this afternoon, and there that same factual circumstance presented not to one of my clients, but to someone else. And so there's a will, and the will appoints, for this purpose, we'll say John, appoints John as the personal representative, the executor of the estate. Yet one of the other children have come in now, and they have filed in the probate court a petition to appoint them as the personal representative. And so John gets the letter in the mail, the paperwork from the court saying a petition's been filed and seeking to appoint the other child as the personal representative, and he's trying to figure out what to do. Let me tell you the first thing you don't do. The first thing you don't do is sit on your hands. If you sit on your hands when it comes to probate or almost any other proceeding, then it's not going to go well for you. And so you can't sit on your hands. If you get served with a pleading, you need to file a response to it. I recommend that you consult with an attorney and retain an attorney to represent you. But if you're not going to do that and you disagree with the papers that were served on you, you should file a response with the court. You're not going to be able to go to court and just stand up and say, "Judge, I object to what they're doing." And the reason why is because courts are courts of record. And so you speak to the court through the paperwork you file, and then the court speaks to you and to all the other parties by the order that it enters. So the first thing is don't sit on your hands. The second thing is you've got to figure out, is this something you want to happen, that is have the other child be a personal representative, or do you want to serve? If you don't care whether you serve or she serves, then you can do nothing. And then she will be appointed the personal representative if you don't object. And maybe there's some reasons why you don't want to be the personal representative. You don't want to fool with it. Maybe you live a long distance away. Maybe you think it's going to be a real mess. There's any number of reasons why you might say, look, I know I was appointed under the will, but I don't want to fool with this. But you got to make that decision. But the main thing is you can't just sit there and fail to take any action at all. Probably if you wanted my advice, I would say the first thing you need to do when you get the paperwork is read it. If you don't understand it, contact a lawyer. If you do understand it and you oppose the relief, hire a lawyer to help you. Legal matters are complex. And if you decide to represent yourself, which you're entitled to do, you will be held to the same standard as the lawyers, which means you're going to have to know the rules. You're going to have to file the proper paperwork, and you will be bound by the result. And I really don't think you should do that without a lawyer. I hope this video was helpful for you. And if you're seeing us on YouTube, would you go ahead and just subscribe to the channel? That way you'll get noticed when we publish new videos. We do that all the time. And if you know somebody that might need this information, go ahead and share the video. You know, I would love it if you would do that, and I can tell you they would appreciate it as well. Talk soon.